The most common reasons that we see workers' compensation claims being denied in North Carolina are, first, that the employee didn't properly report it to the employer. There are a couple of different reasons that the employer will contend that it wasn't properly reported, which would be inaccurate. The first and foremost that we see is that it wasn't reported within 24 hours. That is just not the case in North Carolina. Statutorily, the report of injury must be written to the employer within the first 30 days. There is no 24-hour reporting requirement. Additionally, in order for the 30-day requirement, in order to be enforced by a deputy commissioner or the industrial commission in general, the employer is going to have to show that they were prejudiced by the fact that the employee did not report it. So it is not a complete bar on your claim if you do not provide even the written notification within the first 30 days. So if you've been injured on the job and it hasn't been reported, give us a call and we'll talk about whether or not that claim can still be filed. Another issue that we often see with reporting is it wasn't reported to the medical provider. That means it doesn't show up in the first few medical records after the injury. Oftentimes, the employer or the insurance company will deny the claim because there's no mention of an injury by accident that happened on the job in the initial medical records. This may be true for various different reasons, which would not bar an injured employee's right to a compensable workers' compensation claim in North Carolina. So if your claim's been denied for failing to properly report the claim, it may not be the case. So give us a call and we can discuss it. Another instance that we see employers and insurance companies denying claims is because they say that the injury was not the occurrence of an accident at work. What I mean by this is oftentimes we see that an employer or insurance company will claim that an employee was doing a normal part of their job when they suffered an injury. The law does require that an injury be sustained through an accident through the course and scope of your employment. However, there are instances where something unusual occurs that may not be openly noticed by either the employee or the insurance company. Particularly, we see this when an employee has to change how they do their job, even though they are performing a normal task. For example, if an employee commonly takes out the garbage on a day-to-day occurrence, then if they suffer an injury to their shoulder while they're throwing the garbage away, most commonly, that's going to be a denied claim in North Carolina. However, there has been instances where the Industrial Commission has found a compensable injury by accident when something unusual happened while they were taking out the trash, such as the trash dumpster that is usually used to accept the garbage was moved to a different location. And as such, the employee had to change the manner in which they were having to discard the garbage. That would be unusual because that had never happened before. That very well could be found to be compensable in North Carolina. Another instance that we see employers or insurance companies deny claims in North Carolina is that they contend that the condition was pre-existing. Say, for example, that someone has a prior back injury wherein they had gone to the doctor in, let's say, the year 2012 because they had injured their back in a motor vehicle collision. They had had a standard course of treatment. They had had physical therapy. Ultimately, they may even had some injections by a pain management physician. However, in 2016, they had completely resolved from treatment. They had not required any additional follow-ups with their medical providers, and they had returned to a job, were working full duty when they injured their back in 2022, lifting a heavy object. Obviously, they had had a pre-existing back condition. However, they had not had recent medical treatment, and they had been able to fully complete their job. Now they have suffered an aggravation of that pre-existing condition. In North Carolina, that would be a compensable workers' compensation claim. So if the insurance company denies their claim, contending that this was pre-existing and that they aren't responsible for it, and the medical practitioner says no, they believe that this individual had suffered an aggravation of a pre-existing condition, that would be a compensable claim in North Carolina. So if you believe that your claim has been wrongfully denied by the employer for any of these reasons or for any other reason, and you don't believe it's right, give us a call. We'll review those circumstances with you, and we'll give you an honest, fair opinion as to whether or not you have a compensable claim.